Welcome, my name is Sasha Moore and I'm delighted to be moderating today's Legal Update, an initiative from Unisearch, Australia's leading and most established provider of expert opinion services. This program has been created to provide bite-sized updates on various matter areas to help the profession stay informed about topical developments, legislative updates, and changes in the respective fields. Speaking of which, building disputes continue to be at the forefront of litigation due to the highly technical and often complex nature of these cases. With us today, we have one of Unisearch's esteemed expert witnesses, Constantine Moschoyiannis, the Principal Director and Registered Architect from Morea Architects, who specialises in building disputes. In this session, Constantine will provide us an overview of the common types of building disputes which are happening right now, what changes in the litigious landscape he's noticed, and what indicators there are for the profession of what's in the horizon for 2025. So welcome, Constantine.
Hi, Sasha. Thank you for having me here.
Oh, it's great to speak to you today. We're also joined here today by Unisearch's Business Development Manager, Christopher Aragnon. Christopher will be providing additional context on Constantine's observations, including insights on what he's noticing about the engagement of experts. Welcome, Christopher.
Thanks, Sasha. Thank you for having me.
Great to have you on board. So let's get into it. So Constantine, I'm going to direct these questions to you, and I'd love to pick your brain from a macro perspective about what are the common types of building disputes at the moment?
Yes, Sasha. The types of building disputes at the moment are around contractual matters, performance matters, and liability. In the contractual area, there is disputes with the contracts, and they become very much a litigious matter for the lawyers, but sometimes they need experts like myself and others to interpret the documents, the drawings and the design, and see where the responsibilities are from an expert opinion. In terms of performance, this is a big area in building disputes. A lot of it is in construction with defects. Everyone may know is very prevalent or appears to be in the industry because there's so many litigations. But there's also matters of design that is being disputed as well. And then thirdly, in terms of liability, matters of work health and safety, slips and falls, they do relate back into building disputes on buildings that have just been completed, and even on buildings that have been completed for a long time ago. I've been getting matters for varied amount of matters on liability for buildings that go back historically, but also during construction. And this is an area where this has become now more common. And that is engaging the experts early on in what appears to be a dispute. We've done. I've gone and done inspections at the start of construction, been given documents and retained for pending disputes further on. I've also been involved in surveying built projects, which ended up being completely demolished and refitted, and had to go in and study the documents and take photos and survey what was there, because that becomes a relevant part of the quantum of what the damages will be when they finally resolve their disputes.
So I might just interject there. So I think a lot of the time when we think of building disputes, we do think of new builds, but it's interesting that you were suggesting that that's not necessarily the case. It's really historical matters as well. So can you provide some clarity on that?
Yeah, well, firstly, there are certain defects that do not reveal themselves initially, particularly with water damage. What could be a leak or a stain in the ceiling could 5 or 10 years later become much more serious. But there is that limit of that timeline for limitation of liability. But nevertheless, that the problems are there. And when things are built that may not comply to the building codes in terms of stairs and landings and access ways, and end up having tripping hazards due to non-compliance, and the building was finished 10 or 15 years ago, there's still an issue there for trying to find who is liable. And it could be previous owners and whatnot. So the lawyers will open it up, rope everyone in, and from our point of view as an expert, they'll bring me in to form an opinion and say, look, here is a hazard. What is the issue here on compliance? And we'll go check and the regulations at the time and form an opinion what we think should have happened then.
Okay, fantastic. Well, moving on from that, in terms of the changes in the corresponding litigious landscape, what have you noticed in terms of the evolution and the types of disputes?
From my perspective, I've noticed that that the lawyers will rope in many experts now. The nature of construction is technical and difficult for non participants in the building industry to understand. Some lawyers understand construction very well with their experience, but our job is as an expert to form an opinion for the benefit of the court, to explain to the judge what we think is the problem. And they've brought in now a lot of experts with different opinions, which create then not an agreed position that has led to conclaves and even appearing in court, presenting different opinions between the experts, where then the judge will decide who they think or what part of the evidence they should adopt to make their decision. The nature of contracts has changed in terms of the larger projects now being very much design construct contracts, different contractual process for procuring buildings in the past, where the builder takes on a lot of design responsibility, who in turn, what has changed is has put more responsibility on the subcontractors for that design component as well. So there's a series of subcontracting. But nevertheless, at the end of the day, when there's a failure in the building, there's a defect, it'll come up that there may be a design issue. We need to investigate the documents, design, who was responsible. And that's brought in more players into the litigation and more experts to sort that out. In addition, the other changes that I have noticed, as I mentioned earlier, was some legal practices will engage experts early on to ensure that they've got the evidence to form the opinion, and that can be very helpful because, you know, if there's matters like in the ground services and even structural, you don't get the ability to go underground and do destructive investigations to see what happens. But if you have the early photographs in the early brief, then you can form an opinion during construction, perhaps what happened compared to what should have contractually at the beginning.
Indeed. So then taking that then the next step, what should litigators in the space expect for the sector for 2025?
Well, I think it's going to be pretty much more of the same, consistency of where we've been, but at the same time, the uplift graph of building disputes that we've experienced in the last 10 or 15 years, I think will continue on a rise. I can't see it going down, and we're discovering, you know, every day matters, defects, and significant structural defects like the tower and other matters. But in addition, I can see there will be changes brought about by legislation. So, for example, in Victoria, they're consolidating the building authorities to make a larger commission, and the focus will be on the residential. And in New South Wales, they're approaching it in a different way. And we have a federal government that's also pushing for more residences. So these changes invariably may affect building disputes down the track. Hopefully there'll be less, but we don't know if they would. And the strata issue is also a big issue as well with apartments. There is dissatisfaction from the consumers, and I don't know how that will pan out from a political point of view in dealing with it, but it may then ultimately come back into the litigation with lawyers having to resolve or advocate for disputes. Thank God we've got lawyers and courts.
Indeed. Well, thank you for your insights. I might throw to you, Christopher, from a sector perspective, and as Constantine's just mentioned, I understand that there's been an uplift in building disputes in terms of the matters managed, resolved, and coordinated by Unisearch. What have you noticed about the engagements of experts with building dispute matters?
Thanks, Sasha, and thank you, Con, for your contribution. We're seeing a lot of key trends in how experts are engaged in litigation, both in the court and on the client side. So the first thing is independence is still a non-negotiable. The courts are placing greater emphasis on expert impartiality. So the experts have to assess the facts objectively, and they have to avoid aligning with the interests of the party engaging them. The moment an expert appears to be an advocate for one side, they really compromise their credibility and their compliance with the code of conduct. The second is that disputes, as Con mentioned, are more complex and they often require multiple experts. So the data and our experience shows that high stakes litigation increasingly demands input across multiple disciplines. Con talked about technical requirements. There's also financial and regulatory components. This requires a clear coordination and a really well-defined area of expertise so that experts stay within their swim lanes. And that's something that Con is amazing with. And the last thing is that experts have to show they're working. So a strong CV isn't enough. The courts and our clients demand transparency. So how did the expert arrive at their conclusion? Really, every assumption, their methodologies, the data points, they have to be clearly articulated and tested. And of course, if the reasoning isn't explicit, there's a risk the evidence won't be accepted by the courts. Of course, we're all human, we get things wrong. So if an expert is open to constructive challenge or other views, that's always a real plus. So in short, courts and clients, they're really raising the bar. Expert evidence has to be independent, it has to be justified, and it has to be within the expert's area of expertise.
Fantastic. Thank you so much, Chris. Well, it is definitely a multi-dimensional topic. And as you've all both rightly pointed out, it has all of the signs of continuing to be complex. It is good to hear that experts are being involved early in a matter my perception is that the profession, both the building as well as legal, are taking a more proactive view, hopefully with that disputes being mitigated in the future. So thank you so much for your insights and being part of today's legal update.
Thank you.
Thank you. Thank you, Sasha. Thank you, Chris. Bye.